Welcome back to SCOTUS Oral Arguments and Opinions. Today, I'd like to highlight 4 cases that the Supreme Court recently agreed to hear. 2 cases involve transgender rights in sports, including possible extensions of Skrmetti. 1 case involves religious liberty, and 1 case involves a claim of sovereign immunity when a transit bus collides into a pedestrian. Let's dive in. Within weeks of deciding Skrmetti, on July 3rd, the court took not 1, but 2 cases challenging state laws that exclude transgender athletes from girls' sports teams. As you recall, on June 18th, the court decided United States versus Skrmetti, which we covered in our previous episode. That case upheld Tennessee's ban on certain medical treatments for transgender minors, ruling that such laws don't trigger heightened constitutional scrutiny because they classify based on medical use and age, not sex or transgender status. During oral argument, the justices probed the lawyers about how their arguments would apply to women's sports. What stood out is how quickly the Supreme Court moved. After issuing major rulings, the Supreme Court typically allow percolation, letting lower courts wrestle with new precedents before stepping in again. But that's not what happened here. The court could have done what it often does, issue a GVR order, meaning grant, vacate, and remand. Here's how GVRs typically work. When the Supreme Court issues a decision that affects pending cases, the court often grants the petition for review, vacates the lower court's judgment, and sends the case back for reconsideration in light of the new precedent. This approach lets lower courts apply the new legal framework first, potentially resolving the case without Supreme Court intervention. The court uses GVRs frequently, sometimes dozens per term. They're an efficient way to ensure lower courts follow new precedents without the Supreme Court having to decide every case individually. Lindsay's lawyers even suggested this approach in their brief, acknowledging the court could hold their case pending Skrmetti and then either deny review or issue a GVR. But the court rejected this path entirely. Instead of letting the lower courts reconsider the cases under Skrmetti's framework, the court chose to hear the case directly. This choice reveals something significant about the court's intentions. One reason is that the court may worry that lower courts will try to distinguish Skrmetti narrowly. Courts sometimes limit precedents to their specific facts, here arguing that medical treatment bans differ fundamentally from sports participation rules. By taking these cases directly, the court prevents such distinction attempts. Second, this approach suggests the court wants to establish comprehensive constitutional rules across multiple transgender rights contexts immediately. Rather than allowing gradual development case by case, the court appears determined to create a unified framework quickly. Third, the timing indicates institutional impatience with the current legal uncertainty. 25 states have passed sports laws similar to Idaho's. The court may want to resolve their constitutional status definitively rather than letting litigation continue for years. Let's start with Little versus Hecox. Idaho passed the Fairness in Women's Sports Act in 2020, categorically banning transgender women and girls from participating on women's sports teams from elementary school through college. Lindsay Hecox, a transgender woman at Boise State University, challenged this law after wanting to try out for the women's cross-country and track teams. A federal district court issued a preliminary injunction allowing Lindsay to try out, though Lindsay ultimately didn't qualify for the NCAA teams. The Ninth Circuit Court of Appeals affirmed the preliminary injunction, but used reasoning that Skrmetti appears to have rejected. What stood out here is how differently the Ninth Circuit approached similar constitutional questions. The court applied heightened scrutiny to Idaho's sports law, finding it likely violated the Equal Protection Clause because it discriminated based on both sex and transgender status. The Ninth Circuit suggested that traditional biological definitions of sex were oversimplified and that gender identity should factor into legal definitions of sex. The court also found transgender status constitutes a quasi-suspect class deserving heightened constitutional protection. This reasoning directly conflicts with Skrmetti's approach. The Supreme Court emphasized that sex means biological sex determined at birth, period. The court rejected the idea that laws referencing biological sex automatically trigger heightened scrutiny, especially in contexts where biological differences matter. Under our constitutional system, most laws get rational basis review. Courts uphold laws if legislators had any reasonable justification. But some laws get intermediate scrutiny, where states must prove their classification serves important government objectives and relates substantially to achieving those goals. From a litigation perspective, this sequence creates interesting dynamics. Idaho's lawyers can now argue that Skrmetti controls their case completely. They'll say Idaho's law simply creates a biological sex classification that gets rational basis review, just like Tennessee's medical law. Lindsay's legal team faces a much tougher challenge. They'll need to distinguish sports participation from medical treatment restrictions. They might argue that excluding someone from educational opportunities deserves different constitutional treatment than regulating medical procedures. But Skrmetti's reasoning seems to cut against these distinction attempts. The Supreme Court emphasized biological definitions of sex and legislative deference in areas of scientific uncertainty. Both principles arguably apply equally to sports and medical contexts. Given Skrmetti's framework, the Supreme Court will probably find that Idaho's sports law creates a permissible biological sex classification that receives rational basis review. Under that deferential standard, Idaho's law almost certainly survives constitutional challenge. States have documented interest in preserving competitive opportunities for biological females in athletics. Biological sex classifications serve those interests reasonably well. The court might issue broader language than strictly necessary, establishing clear constitutional boundaries for transgender rights in educational contexts. This could effectively end similar constitutional challenges nationwide. What's happening here fits into broader patterns in the Supreme Court's recent work. The court has shown willingness to use its discretionary review power aggressively to advance preferred constitutional interpretations. We saw similar patterns with affirmative action cases where the court addressed both college admissions contexts in a single term. The court seems comfortable making sweeping constitutional changes quickly when the majority coalition feels confident about the direction. The rapid sequence from Skrmetti to Little reveals a Supreme Court operating with clear strategic intent. Rather than allowing gradual doctrinal development, the court appears determined to establish comprehensive rules governing transgender rights issues quickly. Whether you support or oppose these developments, the institutional dynamics are remarkable. We're witnessing coordinated constitutional architecture designed to settle complex cultural and legal debates definitively. The court will hear arguments in Little v. Lindsay Hecox sometime next spring, with a decision expected by summer 2025. Given the groundwork laid in Skrmetti, that decision could reshape the constitutional landscape around sex, gender, and educational athletics for decades to come. West Virginia versus B.P.J. A different angle on the same questions. Now let's turn to the second case the court granted that same day, West Virginia versus B.P.J. This case presents the same basic constitutional questions, but with crucial differences that help explain the court's strategic thinking. West Virginia passed HB 3293 in 2021, which categorically bans transgender girls from participating on all-girls sports teams from middle school through college. The law applies regardless of individual circumstances like hormone treatments or athletic ability. B.P.J. is a 14-year-old student who was designated male at birth but has identified as a girl since third grade when B.P.J. socially transitioned. West Virginia officially recognizes B.P.J. as female on her amended birth certificate. B.P.J. takes puberty blockers, meaning she never experienced male puberty or the testosterone effects that typically create athletic advantages. B.P.J. consistently places near the back of the pack in cross-country races. She doesn't place high enough to qualify for track running events, though she has improved in field events like shot put and discus. Importantly, B.P.J. appears to be the only transgender student affected by West Virginia's sports law. The procedural history reveals interesting dynamics. Initially, a federal judge granted B.P.J. a preliminary injunction allowing her to compete on girls' teams. But after extensive discovery involving thousands of pages of expert testimony, the same judge reversed course and ruled for West Virginia. The court ruled against B.P.J. on Title IX, the 1972 federal law that prohibits sex discrimination in education and has long been understood to allow separate sports teams for boys and girls. but the court found potential equal protection violations under the 14th Amendment, sending the case back for more factual development about whether transgender girls who never undergo male puberty have athletic advantages. The Fourth Circuit essentially said, "We can't determine if this law violates equal protection as applied to B.P.J. until we know whether preventing unfair athletic advantages actually applies to her individual situation." This approach contrasts with West Virginia's preferred analysis. The state argued courts should evaluate whether biological sex classifications are generally valid, not whether they make sense for each individual case. West Virginia's arguments mirror those we saw in the Lindsay case. The state argues circuits disagree about whether biological sex classifications trigger heightened constitutional scrutiny. West Virginia contends that even transgender girls who take puberty blockers retain physiological advantages over biological females. But West Virginia adds a crucial procedural argument. The state claims the Fourth Circuit misapplied constitutional law by requiring West Virginia to justify the law's application to B.P.J.'s specific circumstances. West Virginia argues courts should evaluate whether sex-based classifications are valid generally, not case by case. B.P.J.'s response strategy focused heavily on avoiding Supreme Court review entirely. B.P.J.'s lawyers argued no genuine circuit split exists because only one circuit has addressed transgender sports participation specifically. Other courts address different contexts like bathrooms or medical care. Most significantly, B.P.J. argued the court should wait for Skrmetti before deciding this case. B.P.J. contended that Skrmetti would resolve the fundamental questions about constitutional scrutiny levels, making immediate review unnecessary. Here's where the strategic maneuvering becomes fascinating. West Virginia's petition acknowledged Skrmetti, but argued the cases address different constitutional contexts. West Virginia claimed that the importance of a state's interest and the relative fit between that interest and the state's solution are different in the context of saving women's sports versus protecting children from experimental and harmful medical interventions. B.P.J.'s response attempted to turn this argument around. B.P.J.'s lawyers noted that the Sixth Circuit in Skrmetti explicitly held that Bostock applies only to Title II, precisely the circuit split West Virginia claimed existed. B.P.J. argued that once Skrmetti resolved the general level of scrutiny questions, lower courts could apply those principles to athletics through normal development. B.P.J. essentially advocated for constitutional incrementalism. Let the court decide the big principles first, then allow lower courts to work out the applications. B.P.J. argued there was no good reason to short-circuit that percolation by granting certiorari in this as-applied challenge. The Supreme Court's decision to grant both cases on the same day represents a clear victory for West Virginia's strategic thinking. The court rejected B.P.J.'s wait-and-see approach entirely. By granting certiorari despite B.P.J.'s arguments, the court implicitly agreed with West Virginia that different contexts require immediate clarification. The court appears convinced that sports participation raises distinct constitutional questions that Skrmetti alone won't resolve. This choice reveals a court confident about its direction and unwilling to let constitutional doctrine develop gradually. Instead of allowing lower courts to apply Skrmetti to athletics cases over time, the court wants to establish comprehensive rules across multiple transgender rights contexts simultaneously. The grant also suggests the court rejected B.P.J.'s characterization of the case as a narrow, individual challenge, unsuitable for broad constitutional pronouncements. The court apparently views these cases as appropriate vehicles for establishing national constitutional principles. What's particularly telling is the court's rejection of traditional judicial restraint principles. Courts typically allow time for constitutional precedents to percolate through lower courts before stepping in again. The rapid sequence from Skrmetti to these sports cases shows a court operating with unusual urgency and comprehensive vision. Let's turn next to a religious liberties case, Olivier v. City of Brandon. What stood out here is how a simple street preaching arrest in Mississippi has now landed before the Supreme Court. Gabrielle Olivier travels around sharing the Christian gospel on public streets. In 2021, Olivier got arrested at Brandon, Mississippi's amphitheater for violating a protest ordinance. Olivier pleaded no contest, paid a $304 fine, and moved on. But then Olivier filed a federal civil rights lawsuit seeking an injunction to prevent future enforcement of the ordinance. The city fired back with a legal doctrine called Heck vs. Humphrey. Here's where things get complicated. The Supreme Court decided Heck vs. Humphrey in 1994. The basic rule says you cannot file a civil lawsuit that would necessarily imply your criminal conviction was invalid. If winning your civil case would prove the government wrongly convicted you, federal courts will not hear that case. But here's the question. What happens when someone wants to prevent future enforcement rather than challenge past convictions? Federal appeals courts have dramatically different interpretations of Heck. The Fifth Circuit takes a hard line, saying Heck bars civil rights lawsuits seeking injunctive relief when plaintiffs were previously convicted under the challenged law. The Ninth Circuit says the opposite. The court reasons that preventing future enforcement does not necessarily invalidate past convictions. The Tenth Circuit appears to agree with the Ninth Circuit. Olivier makes two main arguments. First, Heck should never bar claims seeking purely prospective relief. Olivier does not challenge the 2021 conviction, but seeks protection against future prosecutions. Second, Olivier argues that Heck should not apply when someone never had access to habeas relief. Olivier never went to jail, only paid a fine. Brandon argues that Olivier never properly presented these arguments in lower courts. The city points out that Olivier originally sought both damages and injunctive relief, not purely prospective relief. Brandon also argues that recent circuit decisions show growing uniformity in applying Heck beyond prison walls. This case could reshape civil rights enforcement nationwide. Right now, similarly situated plaintiffs face different outcomes depending on geography. The decision will particularly impact religious speakers, protesters, and demonstrators who face repeat citations under laws they believe violate constitutional rights. The Supreme Court's decision to hear this case signals the justices view this as a fundamental question requiring definitive resolution. The ruling will establish uniform nationwide standards for civil rights litigation involving repeat constitutional violations. A local dispute over amphitheater protests has evolved into a vehicle for resolving fundamental questions about federal civil rights enforcement. The court will decide whether Heck versus Humphrey creates an absolute bar to prospective relief claims, or whether federal courts can protect future constitutional rights even after past convictions. We will continue following this case through oral arguments and decision. The stakes extend beyond one street preacher to the fundamental question of how Americans vindicate constitutional rights in federal courts. Finally, let's discuss New Jersey Transit Corporation versus Jeffrey Colt. This case was consolidated with Cedric Gillette versus New Jersey Transit Corporation. In this case, a Manhattan pedestrian accident transformed into a Supreme Court case about the fundamental relationship between state power and individual rights. As Jeffrey Colt crossed a Manhattan street with a traffic signal, a New Jersey Transit bus struck him while making a left turn. Colt suffered multiple fractures. Colt and his wife sued New Jersey Transit and the bus driver in New York State Court for negligence. Here's where it gets interesting. New Jersey Transit participated in discovery for nearly 3 years without mentioning immunity. Then in July 2020, after the Supreme Court's decision in Franchise Tax Board vs. Hyatt, New Jersey Transit suddenly claimed sovereign immunity and moved to dismiss the entire case. The Supreme Court's Hyatt decision in 2019 fundamentally changed interstate sovereign immunity. Previously, state courts could decide whether to grant immunity to another state's entity based on comity principles. Now, state courts must give immunity to any entity that qualifies as an arm of the state. But here's the million-dollar question. When does a state-created entity qualify as an arm of the state? Courts look at several factors. How does the state define the entity? How much control does the state exercise? Most controversially, what happens to the state's treasury if someone wins a judgment against the entity? This last factor, called the treasury factor, split federal appeals courts and now state Supreme Courts. The procedural history reads like a legal drama. The New York trial court denied NJ Transit's motion, finding the agency waived immunity by waiting 3 years. The New York Appellate Division said NJ Transit had immunity, but equity required allowing the suit because plaintiffs had no remedy in New Jersey courts. Then the New York Court of Appeals took a completely different approach. the court held that NJ Transit simply is not an arm of the state entitled to immunity at all. But travel to Pennsylvania, and you get the exact opposite result. The Pennsylvania Supreme Court looked at the same legal entity and concluded that NJ Transit clearly qualifies for sovereign immunity protection. New Jersey Transit makes two core arguments that really crystallize the broader legal tensions here. First, New Jersey Transit argues that courts wrongly focus on the Treasury factor. The agency points out that New Jersey characterizes NJ Transit as an instrumentality of the state exercising public and essential governmental functions. New Jersey Transit exercises sovereign powers like eminent domain and police authority. The governor appoints the entire board and can veto any board action. NJ Transit's lawyers argue that New Jersey's disclaimer of financial liability actually demonstrates sovereignty, not the absence of it. States protect their treasuries precisely because they are sovereigns. Second, New Jersey Transit emphasizes the practical chaos created by conflicting court decisions. The agency operates across multiple states but faces different immunity rules in each jurisdiction. NJ Transit calls this an untenable situation, where immunity toggles on and off depending on courthouse location. Colt's response takes a fundamentally different approach to sovereign immunity doctrine. Colt argues that the New York and Pennsylvania courts applied identical legal tests but reached different conclusions because they read New Jersey state law differently. Colt emphasizes that New Jersey's tort liability statute explicitly excludes NJ Transit from the definition of state. The statute says the state shall not include any such entity which is statutorily authorized to sue and be sued. Colt also raises a fascinating historical argument. At the time of the founding, corporate entities with power to sue and be sued were never considered sovereigns. Early Supreme Court cases held that states divest their sovereign character when creating separate corporations. Colt argues that the modern arm of state test represents a departure from original constitutional understanding. What really grabbed my attention is how this case affects every American who uses public transportation crossing state lines. Consider the current situation. If you get injured by an NJ Transit bus in New York, you can sue in New York court. If the same bus injures you in Pennsylvania, sovereign immunity might bar your lawsuit entirely. The location of your accident, not the nature of your injury, determines your legal rights. This extends far beyond NJ Transit. Transportation authorities, state universities, public hospitals, and port authorities across the country operate interstate. The court's decision will determine whether these entities can claim immunity when they cause harm outside their home states. The consolidation with the Pennsylvania case signals that the court wants to end this geographic lottery once and for all. The Supreme Court's decision to hear this case sends several important signals about federal constitutional law. The justices clearly view this as a fundamental question about state sovereign immunity that requires uniform national resolution. The court has repeatedly emphasized that constitutional protections should not vary based on geography. The decision will also clarify the relationship between interstate sovereign immunity and 11th Amendment immunity. Lower courts have struggled with whether the same standards apply in both contexts. Most significantly, the ruling could trigger massive restructuring of state government entities nationwide. If the court adopts Colt's historical approach, hundreds of state corporations could lose immunity protection overnight. We will continue following both consolidated cases through oral arguments and decision. The stakes extend far beyond one bus accident to the fundamental question of how states can exercise power while remaining accountable to the people they serve, regardless of state boundaries. That's it for today's episode. Thanks for listening to SCOTUS Oral Arguments and Opinions. If you enjoyed, please rate, subscribe, and share. Talk you soon.